You already know these words. You've heard them in films and news clips, maybe shouted across a television set. You have the right to remain silent. Anything you say can and will be used against you in a court of law. It is almost certainly the most famous sentence in the history of American law. And here is what almost no one realizes. It did not always exist. There was a version of America where police could question you for hours, never tell you any of this, and use every word against you. The sentence you've memorized is younger than color television. It was born from a single court case, and that case began by setting a confessed criminal free. This is the story of how one idea, the right to remain silent, was written into every arrest in America. And it comes with a deeply uncomfortable twist because the man whose name is on that ruling did not walk away free. To understand why your rights are read aloud on street corners today, we have to go back to a police station in Arizona in the spring of 1963. One note before we begin. This is legal history and education, not legal advice. Phoenix, Arizona, March 1963. A 22-year-old laborer named Ernesto Miranda is arrested at his home and driven to a police station. A young woman had been abducted and assaulted days earlier, and Miranda matched the description. At the station, he was placed in a lineup, then led into a small interrogation room. What happened in that room over the next 2 hours would eventually be argued before the highest court in the country. 2 detectives questioned him. There was no lawyer present. No one told Miranda that he could stay silent or that he could ask for an attorney. After about 2 hours, he confessed and then wrote and signed a statement describing the crime. Printed at the top of that statement was a paragraph certifying that he had given it voluntarily and with full knowledge of my legal rights. It is a chilling detail. He was signing away rights that no one in that room had ever told him he had. At trial, that written confession was read to the jury. It was the heart of the case against him. Miranda was convicted of kidnapping and rape and sentenced to 20 to 30 years in prison. He appealed to the Arizona Supreme Court, arguing the confession should never have counted. That court disagreed and upheld the conviction. By every ordinary measure, the case was finished. But the appeal had raised a question the country had never squarely answered. That question lived inside the Fifth Amendment to the United States Constitution. The Fifth Amendment makes a famous promise that no person shall be compelled in any criminal case to be a witness against himself. We usually call this the privilege against self-incrimination, the right not to be forced to hand the government the evidence to convict you. For most of American history, that protection was understood to apply inside the courtroom. But Miranda never refused to talk in a courtroom. He talked in a locked room, surrounded by detectives. So the question was this: does the Fifth Amendment reach inside the interrogation room? Before 1966, the answer was murky. Courts mostly asked whether a confession had been voluntary, whether police had beaten it out of someone, or starved them, or threatened them. If the pressure was quieter, isolation, exhaustion, hour after hour of questioning, the confession usually stood. The trouble is that almost everything about an interrogation is designed to apply pressure. And a suspect who didn't know he could stay silent or didn't know he could ask for a lawyer often never used rights he technically already had. The protection existed on paper. In practice, it could quietly vanish. Miranda's case reached the Supreme Court of the United States in 1966, and it did not arrive alone. The court combined it with 3 other cases raising the same basic problem. Suspects questioned in custody, without warnings, whose statements were then used to convict them. Because Miranda's name came first, the entire landmark took his name. The justices now had to decide not just one man's fate, but a rule for the whole country. The argument on Miranda's side was simple. A police station is not a neutral place. When you are taken into custody, held, isolated, and questioned by officers, the situation itself is coercive. Lawyers call it custodial interrogation, questioning after a person has been taken into custody or otherwise deprived of his freedom in a significant way. In that setting, the argument went, a confession cannot truly be called free unless the suspect actually knew his rights. Without that knowledge, the Fifth Amendment was a promise the system was failing to keep. The states pushed back hard. Confessions, they argued, are among the most powerful tools law enforcement has. Requiring police to recite warnings and to stop the instant a suspect asks for a lawyer might mean fewer confessions and fewer convictions. Guilty people, they warned, would go free on a technicality. Crime would be harder to solve. The court, they said, was being asked to handcuff the police in the name of protecting the very people the police were trying to catch. On June 13, 1966, the court gave its answer. By a vote of 5-4, it sided with Miranda. The court held that before any custodial interrogation, police must warn a suspect of 4 things: that he has the right to remain silent, that anything he says can be used against him in court, that he has the right to an attorney, and that if he cannot afford one, an attorney will be appointed for him. If those warnings are not given and knowingly waived, then whatever the suspect says generally cannot be used against him at trial. The sentence you have heard your entire life was, in that moment, written into law. The majority opinion was written by Chief Justice Earl Warren, and his reasoning was about pressure. The purpose of the warnings, Warren explained, was to counteract the inherently compelling pressures of being questioned in custody, to make sure that when someone chooses to speak, the choice is genuinely theirs. The rights were not new. The Fifth Amendment had always been there. What the court added was a practical safeguard to make that right real for a person who might not know it existed, including someone too poor to hire a lawyer who could have told them. But remember, this was a 5-4 decision. 4 justices dissented, and their warning was blunt. They argued the court was inventing a rule with little footing in the Constitution's actual text, and that the cost would be paid in confessions lost and crimes left unsolved. Society, one dissent argued, was being asked to pay a heavy price for an unproven benefit. That tension between protecting the accused and empowering the police never truly went away. It still runs underneath this case today, which brings us to the twist. Winning at the Supreme Court did not set Ernesto Miranda free. The court threw out his confession, but it never said he was innocent. It sent the case back, and Arizona simply tried him again. This time, prosecutors did not have the confession, but they had something else. Testimony from Miranda's estranged partner, who told the court that he had admitted the crime to her. On that evidence, in 1967, Ernesto Miranda was convicted a second time and sent back to prison. He was paroled a few years later, and here the story turns almost unbelievable. After his release, Miranda reportedly earned spare money by autographing the small printed cards that police officers carry. The cards with his own warning on them. Then in 1976, he was stabbed to death during a fight in a Phoenix bar. According to multiple accounts, when police detained a suspect in the killing, they read that man his Miranda rights. He chose to stay silent. No one was ever convicted of the murder. The man who gave the warning its name was in the end protected by it, and so was the person accused of killing him. So is the Miranda warning still the law? Yes, but it has been tested again and again. In the year 2000, in a case called Dickerson, the Supreme Court reaffirmed Miranda, struck down an attempt by Congress to undo it, and called it a constitutional rule. Over the years, the court also carved out limits. There is a public safety exception. If officers ask about an immediate danger, like a hidden gun, that answer can be used even without warnings. And in 2022, the court ruled that violating Miranda on its own does not let you sue the officer for damages. But the core still stands. No warnings, and your words generally cannot be used against you at trial. And that is the quiet power of this case. Miranda is not really about one man, or even about confessions. It is about a simple idea, that a right you don't know about is barely a right at all. A protection only the educated, or the wealthy, or the well-advised can use is not equal protection. By forcing the state to say the words out loud to every person it detains, the court tried to close the gap between the rights we have on paper and the rights we can actually use. That is why those words are spoken in patrol cars and police stations every single day. So the next time you hear that famous sentence, remember where it came from. A contested 5-4 decision, a man who was convicted anyway, and an argument about power that we are still having. Was the court protecting the innocent or shielding the guilty? More than half a century later, thoughtful people still disagree. If the cases that quietly shape the rules we all live under are the kind of thing you want to understand more deeply, consider subscribing. We take one landmark case at a time, and we try to get it right. Thank you for watching. And remember, this video is for education and history. It is not legal advice.